Hello, my name is Professor Oluwakemi Adekile. This presentation will be taking you through the thought of negligence, the thought of negligence. And I want to first start by telling you that you should pay attention, particular attention to the discussions that we'll be having on this topic. Because if you look at any standard tort textbook, you would notice that the discussions on the thought of negligence occupy major sections of those texts, sometimes 7 chapters, hundreds of pages. And most standard texts tell you that the thought of negligence is the most significant, most important of all thoughts. And why this is so, we'll discuss as the presentation goes on. It is one thought that is very fluid, that can be used in diverse situations of life. And I know you recall what the law of tort is about and what it tries to do. It tries to regulate the way we behave in the society, makes us to know that irrespective of contracts, there are some duties that the law has placed upon us in life that we must, that the law would have to activate if we fall short of the standard that has been prescribed by law. So, but in this presentation, we'll be looking at the thought of negligence. I'll be introducing you to what it means to say somebody is liable in law for the thought of negligence. That is negligence as a cause of legal action, not just the ordinary use of the word negligence. And we'll also be looking at what the law requires of you to establish before you can say someone is liable. We'll be looking at questions of what it means to have a duty of care, what it means to breach that duty, to fall short of the standard of the law, and what the issue of damage encompasses. Because one of the first things you must know is the fact that the thought of negligence is not actionable per se. I know you know what it means to say it's not actionable per se. That means that you must establish that some form of damage has taken place. So when you say that the damage has occurred, there you can see the third element has been established. So this presentation will introduce you to it, will tell you some of the interests and some of the issues that have arisen in law about negligence, the various forms and uses of the thought of negligence, and what have you. And I want to believe that at the end of the presentation, I'll be able to have some basic understanding of what this thought that is very important it's about. If there's any aspect of law that students of tort cannot afford to forget, it is the thought of negligence. And you know why we're saying this as the discussion progresses. So I will be sharing my screen now so that you can follow my presentation. Okay, so here we are. Here we are. Just hold on. I want to be sure that we are on pause. Okay. So the thought of negligence, I said that is our topic for today. And what are we talking about? In this slide, we'll be looking very briefly at the basic components of the thought of negligence. You understand, like I said at the introductory stage, the meaning of the thought. You would understand the various forms out, is it common law? Is it statute? I know now you already know that law has its, or every kind of law has its standard formulation. And I will be introducing the elements of the thought of negligence, the issue of duty of care, the breach of duty, and damage. And the whole essence that you should be able to understand the legal meaning as a student of law of the thought of negligence. These are our learning house forms. At the end of the day, at the end of the discussion on negligence generally and some aspects of this presentation, you will be able to distinguish negligence from the thought of negligence, understand the basic elements, like I said, understand, especially in this slide, in this presentation, the meaning of duty of care. In later presentations, you'll be able to understand the key issues of negligence application to different case scenarios. I would like to emphasize one basic thing, that as a student of this topic, you must have some things at the back of your mind when you are looking at the thought of negligence. You ask yourself some fundamental questions, because you would see that when you look at the cases that we'll be discussing, you may seem like you are getting lost, that what exactly is standard rule of law regarding some specific situations that we'll be looking at. To help you, I want you to pay attention as you read your cases, as you listen to your discussions in lectures, and ask yourself, the complaint of the complainant, is it a complaint about an act, something that someone has done, or an omission, a failure to do something? Have that at the back of your mind. When you look at any fact, set of facts, whether in your case report, whether in class during discussions, whether during the examinations, are we talking about an act, something someone has done, like someone, for instance, driving a car, or an omission, for instance, like someone failing to do something, like, it's a teacher failing to supervise the child appropriately, or a man standing by the roadside and seeing some children trying to cross the road and refusing to assist them, failing to assist them to cross the road. Are you talking about what? Then you ask yourself, what kind of injury are we talking about? At your introductory classes in the law of tort, some of you would have been told that tort protects diverse forms of interest. It can be personal injury, security of your person, the right not to be injured, the safety of your person. It can be property damage, security of your assets and property, your car, your houses, your buildings, whatever you can call property. It can be an interest in financial security. Don't cause economic loss. Some torts are designed to do that, to protect, some torts are designed to protect your reputation, like defamation. Some torts are designed to protect your mental health, psychiatric injury. So in this discussion on the tort of negligence, I want you to pay attention to and ask yourself, the complaint, what is it about? Is it by an injury to my person, injury to my property, injury to economic, financial security? Has it caused me a loss? If I read in the newspapers that a bank is doing very well, and I decide, maybe because of the financial reports of the bank, I decide to rely on that report and go and buy shares in the bank, and it now it is later discovered that the bank was not doing as well as the report has presented. Am I in a position, because of these laws, to sue the person that wrote the report? Is it a psychiatric injury, mental injury, injury to your mental health? You see some cases that we'll be looking at where someone has had a very bad news and they become psychologically damaged, or someone has been involved in a process like a rescue, or witnessed an accident and they are psychologically damaged because of that. Can we say you can get a claim in the sort of negligence? So you pay attention to the kind of injury that occurred. You also pay attention to the person that is claiming. Who is the claimant? These are the things that will help you to understand this discussion on the sort of negligence, to say, okay, this is the applicable in every situation. Is it a primary victim? You'll be hearing talks about primary victims and secondary victims. And the primary victim is usually someone that was directly affected by the act or the omission of the defendant. Is it the person that that was directly involved? For instance, A is riding a car and hits B, and B is injured. B is the person that is the primary victim. But assuming that as that accident occurred, C was watching by the roadside, and because of the extent of the injury to the victim, and B begins to suffer some mental health issues, you talk about B as a secondary victim. So we'll be defining primary victim and secondary victim. You pay attention to those that issue as well when you are trying to determine what is the rule of law regarding a state of affairs. Then you look at who is the person suing, who is the defendant. Is it the person that caused the injury, like A, that has driven his vehicle in a way that has caused injury to B? Is it the person, another person, maybe his employer, or is it a parent or guardian? These are some of the things that will help you to have a clear understanding of the applicable rule in the tort of negligence. Um, so we go to the next slide. Excuse me, the slide seems to be. Okay, so what is the meaning of the tort of negligence? I've already told you that negligence, the tort of negligence is very dynamic. Okay, can apply it to almost every situation of life. In almost any situation of life, whether it is a fact that you went to your doctor and he didn't treat you well, you are walking on the road and somebody has run into you, your neighbor or your building, the house you are living, the collapses and they did not build it well, or someone has written a reference for you and has put in the wrong information, or or your bank has made a wrong transaction and has credited somebody else's account with money that you're supposed to be. It can apply to a situation of life. Uh, but in life, when someone uses the word negligence, it has different connotations. There's negligence in the common or ordinary usage, which means carelessness, being careless, inadvertence. If I put my key in a place and I couldn't find it, someone might say I was careless with it. But does it mean that there's a cause of action? Obviously not. I'm not going to sue myself anymore. So there's a common ordinary usage of negligence. And I'm sure most of you have used the word negligent before. You were negligent, you were careless, you are not being careful enough. There's the legal meaning of the word negligence. In this legal meaning, you have two dimensions. When a lawyer uses or a lawyer or a tort lecturer uses the word negligent, it can be talking about the mental elements of another tort. You would have been told that there are different kinds of torts. You look at some torts like trespass to persons, trespass to goods, trespass to land. You talk about defamation, malicious falsehood, and defamation and all sorts of torts. These thoughts usually require some mental elements for their commission. It can be that you have done the thing intentionally, or you have done the thing maliciously, or you have done the thing negligently. And those mental elements are significant for liability in those thoughts. So negligence can mean the mental element needed for the commission of another thought. Sometimes it's said that trespass is either done intentionally or negligently. If I want to go and I want to drive out and I go to the car park, I want to enter my car and I get there and I see a car that's exactly like mine and I enter the car, only to realize that it's not my car. You might say I've entered, I was negligent, I didn't look very well, but there's a trespass to that chattel. Then, so it can therefore be the mental elements that you need to commit a tort. Negligence today that we are looking at in the light of this presentation can also mean an independent tort, a tort on its own, a course of action that you can go to court and say, I want to sue in negligence, in the tort of negligence. And that is the connotation in which we are looking at to this presentation. So what is the tort of negligence? Pardon me. So we want to define the tort of negligence. What is negligence as a tort, as a course of action in law? What does it mean? When you look at your various texts on the law of torts, you would see the definitions. And there are cases that have defined it. Of course, as a law student, you know that you can define something through a statute, through a case. So the definition of the sort of negligence, I would expect that you look at your cases. I would expect that you look at your texts. There are some statutes that also define it in different jurisdictions. If you, for instance, look at the case of Glasgow Corporation and more, Lord Macmillan, looked at negligence and said, well, it's failure to exercise that degree of care that the circumstances demand. Degree of care. So there's a degree of care that every situation in life demands of us. You also see a definition in Blight and Birmingham Water Company that says negligence is sufficient to do something which a reasonable man would do, or doing what a reasonable and prudent man would not do. So it's either is an act that you have done, which a reasonable man would not do. If you look at that reasonable man in another presentation, who is he? Or doing what a reasonable man would not do. So these are some of the attempts to define negligence, but these definitions are not, they are not, exhaustive when by the time we look at the discussion, because it goes beyond doing something which a reasonable man will not do. In fact, those definitions are more like a definition of what is negligence generally. There are still some elements of the legal connotation of negligence that are missing. This is another statement regarding the thought of negligence. This is by Atia. Says the allegation in a negligence action is basically that the defendant has paid insufficient attention to the interests of others in deciding how to behave. So there is a need for you to understand that you are not an island and you must behave in the way that you consider in the interest of others. You don't work as carelessly, you don't drive in a way that you injure others. You are a doctor, you don't do some, you have to understand that the people that you're attending to your patients can be affected by your not meeting the standards that your profession demands, and so you don't work as if you are the only one in the world. So he argues that therefore there's an element of morality in the connotation of negligence. It's not, but it goes beyond legal moral fault. There is an element of moral fault, but it moves beyond moral fault to a legal fault. So you don't look at things from your own perspective. I say, oh, I've done my best, but the judge is not going to look at whether you have done your best. He's going to look at whether your best is good enough according to the standard society. I'm sure you know that in life, there are things that you expect people to, how can you do that? You cannot, you just know that this person has fallen beneath what he's supposed to do. That no, you shouldn't have done that. You shouldn't have written the document that way. You shouldn't have, you shouldn't have behaved in a particular way. You need to consider, other people. So these are some of the attempts, and I would expect that you read vastly in this regard. In Nigeria, too, you have the statement of the law that says it is now firmly established that for a claim in negligence to succeed, you as a plaintiff must prove that the defendant owes you a duty of care and that the duty of care was breached, and that beyond that, that there is being a damage to you. So the person must owe you a duty of care. Also, there's not like negligence here. You just have to owe a duty of care to that person. And we are going to be looking at what is duty of care today, what really mean by duty of care, and that person has breached that duty that the law has stipulated, and you have suffered some damage. Because like I said earlier, negligence is not actionable per se, and so it's a breach of a legal duty. It is important to understand that it's not a moral duty, a legal duty, a duty that the law has fixed. These duties, you may be aware of them, you may not be aware of them. That's how tort works. But when you are falling beneath the standard, somebody says to you, I say, oh, okay, you have breached the standard of the law, so you are liable for this or that. It's different from contracts. In contract, of course, there's relationship and there's consideration. And so you say offer acceptance, consideration, intention to create legal relations. There is a relationship. Here in tort, you don't have to have known the person before, in terms of liability in tort. And negligence follows that thread of what a tort looks like. So there is a breach of a legal duty. And so you can put it in formula form, say D for duty, B for breach, D for damage, and you have the tort of negligence. If any of those components are missing, the tort of negligence is not established. And all the discussion we'll be having subsequently will be explaining this issue of duty of care, we'll be explaining the meaning of breach of duty, we'll be explaining the meaning of damage. Or you can put it DC, duty of care, DC, breach of duty, breach of duty, damage, and you have tort of negligence. Okay. Someone, I'm sure you've heard of the name Dyers before. It tried to give you some conceptualization of what we are looking at in the discussion on negligence, on the tort of negligence. It says, you ask yourself, you are trying to explain what we mean by negligence. Okay, this person, I want to sue you for the tort of negligence because I gave you my clothes to sew and the clothes are missing, or I gave you my car to ride and the car has become damaged, the engine has knocked, or I gave you the car to repair and the engine has knocked, or I went to the doctor and I wanted to be treated for malaria and they gave me an injection, and then the next thing, the person's leg is paralyzed, or somebody has done a surgery and they wanted to remove something from the abdomen, and by the time the surgery is done, the person was not feeling, it was even feeling worse than before, and by the time they interrogate it, they realize that, okay, they say scissors has been left in the abdomen. Or you look at situations where you go and buy a drink. You want to have a drink, and you take it, and the next thing, the person falls ill or finds a cockroach inside the drink and is emotionally disturbed or physically ill and what have you. These are some of the dimensions. And then in the age, in the brick and mortar world, those are some of the issues that arose in law. But you know that in the internet age, in the borderlessness of the world today, in the cyber world, negligence is also relevant. And in later presentations, we'll be looking at application in this dimension. So it says the careless infliction by an act, what that person has done, or omission, what the person has not done, is it recognized by law? If it's not a breach of illegal duty, if the law does not recognize it as a cause of action, you may not be able to sue in the tort of negligence. You may have other causes of action. It may even be a crime. It may even be a breach of contract. But in law, the law must recognize it as a cause of action. Was the defendant's conduct in the given situation careless? Was he careless? Has it fallen below what we expect in society? It's the standard that has been set by law. Because law, in response to those societal standards, by the time we are looking at the breach of duty, you see that standard, they talk about the reasonable man, what a reasonable man would do, or what a reasonable and prudent man would do. Was it reasonably foreseeable? It's not sufficient that there is a breach. It must be something that is foreseen. Because, for instance, if for instance, I rides a car or a train negligently in Nigeria, and the train has an accident and kills 1,000 people, and everyone is watching, this is internet age. You can see it all over the world. And somebody watches it in Australia, maybe an old woman or a pregnant woman, and the person becomes so emotionally traumatized by the kind of injury and human suffering they see in that accident. And they want to come and sue who is in Nigeria. Can the law permit it? Would the law permit it? The law will ask questions like whether it is reasonably foreseeable. And they will ask whether it's the conduct of the plaintiff that caused damage. It may be, I've done something, but was it the one that caused damage? If all those things are positive, you can say the sort of negligence is established. So it's in mathematical form, therefore, we said earlier, you have duty of care, you have duty plus breach plus damage equals negligence. Omission minus any of them, negligence as a tort is not established. Then, because of that issue of damage, I said earlier, it is not actionable per se. The tort of negligence, you must put the damage as support. Key points to note in defining negligence, therefore, it is fluid. The tort of negligence can be adapted to every situation in life, whether it's performance of your work, economic activities, relationships, professional relationships. It can be adapted to any situation in life. It is usually unintentional harm. It is that why I say it is. If it is intentional harm, you are looking at things like trespasses. It is not that you have intended, wanted to, it's unintentional. And it can have some components of strict liability. I'm sure in earlier classes, you have looked at types of liability. fault-based liabilities, street liability, and what have you. Product liability is an example. You must have actual damage. The person must show that they have suffered a damage. It's not just nominal damages. You must show that, okay, maybe my dress was destroyed, my car was destroyed, or I was healed because I took the drug that was negligently prescribed, or I suffered some economic loss, or emotional trauma, or you must show some loss. Actual damages is required. The thought of negligence in today's world can be based on the common law, case law, or it can be statutes. There are some statutory negligence. In fact, a lot of laws and disciplines of law today are actually negligence, or even more generally, torts that have evolved into a major discipline and have to be taken out of the law of torts, and and created as a separate subject for discussion, so it is easier for students to comprehend. For instance, you're talking about aspects of intellectual property, which is now, based on. So we go on to the next slide. I said earlier that you need to establish first as an element, the first element of the thought of negligence is that there must be a duty of care. If the person does not hold you a duty of care, cannot be held to have been negligent towards you. The duty of care is imposed by law, not contract. When you have a contract, you have interacted with the person and you say, oh, the person has made an offer, you have accepted, there's consideration. In this case, we are not talking about contract, we are talking about a duty that the law imposes over every one of us as we go through our daily activities. There are some obligations, whether you are aware of them or not, that the law has placed upon you. Duty of care is fundamental. It is the start of the inquiry, whether there is the thought of negligence. If you don't establish the duty of care as being imposed, then you don't even go further. You won't go beyond that to the next element. So it is a question of law, whether there is a duty of care or not. So in the scenarios that we have looked at, the driver that is riding on the road, the doctor that is treating you, the banker that you have paid money to, and someone has withdrawn from your account without your knowledge, they owe you a duty of care. This is core. It is the starting point of every investigation in the thought of negligence. Duty of care has been formulated in different ways over the ages. We'll be looking at it every time you are looking at duty of care. Over the course of the discussions, as we go through the next discussions, you'll be hearing things like foreseeability of damage. You can use that to determine whether there is a duty of care. This is usually applied where it's a physical injury to your person that you are talking about. Oh, I have a broken leg. I have I have a running stomach because I took the drug. So if it's your injury to your person or injury to your property, usually you use the principle of foreseeability of damage as discussed in Donegal and Stevenson. Remember I said that case? You can sleep and forget everything in the law taught. Forget Donegal and Stevenson, somebody will question your law degree. Somebody will question it. So you go and familiarize yourself with that case and enjoy it and enjoy the discussion. Read it from the law report. Don't just read it from your textbooks. You talk about proximity test. Look at Hans and Martin. That's another significant case. Try to show that there must be some form of proximity, in terms of formulating duty of care. Then the court can look at whether it is fair, just, or reasonable, and to determine whether there is a duty of care. Then you look at questions of policy. I will be expatiating on this as the discussions go ahead. Reasonable foreseeability. There is the case of Donegal and Stevenson that I mentioned earlier. What has that case got to do with the law of tort? Before the case of Donegal and Stevenson was decided in 1932, there was no general law principle by which you can say somebody is liable in negligence. I told you earlier, I said, well, for there to be negligence, there must be duty of care, there must breach, there must be damage. This is the general formulation of negligence, the sort of negligence as of today. But earlier, before Donegal and Stevenson was decided, the various liabilities in the sort of negligence were piecemeal. You can say, oh, it was not the world was not as developed as today. So somebody was riding their wagon and he runs over the cliff and somebody is injured, they say they are liable. Somebody else kicks the farm boy and in the face and loses an eye, they can say they are liable. But there was no general formulation, no general principle by which you can say somebody can be liable. And this is because of the origin of the law of tort. If you look at the origin of the law of tort, you talk about the fact that you bring your actions through writs. You have the writ of trespass and the writ of case, and you try to fit your course of action into a particular writ, a formula of a document. And if your course of action does not fit that formula, you may not have the ability to sue. But by the time the case of Dogo and Stevenson emerged, one of the things that you will talk about that case is that it created a general principle. What happened in that case was what would happen in everyday life. Hey, Mrs. Dono went to a cafe with her friend, and the friend ordered a ginger beer. As you've done the law of contracts, and you know that the friend that ordered the ginger beer is one that has entered into a what? Into a contract with the bartender, with the bar. She wanted the ginger beer. She ordered ginger beer, and they poured into something like a milkshake. So the bottle, the cup was already filled with a drink like milk, and Mrs. Donoghue then took the ginger beer that has been ordered, poured it into the cup, and drank it. The ginger beer, the remaining, was in an opaque glass. Cannot really see the contents. The friend poured the remaining ginger drink into her own cup, and as she poured it, a decomposed nail tumbled out into the cup. And you can, of course, imagine what would happen for someone that had already drank from that. So Mrs. Donoghue said she suffered emotional shock. She had nausea, she had diarrhea, she had, all the forms of things you can imagine could have happened. And that was the basis of this action in law. Is she like able, can she get a remedy? Either to, it was difficult in that kind of scenario to get a remedy because Mrs. Donoghue, remember I said it was the friend that ordered this ginger beer, ginger drink. So it's the friend that entered into a contract with the manufacturer of that drink. She was just given the drink to drink. So if the friend had been the one that consumed it, it would have been an action in contract. But so where would she place her course of action? She has not offered any consideration. All that she did was to take a drink offered by a friend. And so the law had to determine how do we treat this kind of a case. She was claiming in negligence in tort. She had no ability to sue in contract. She had no ability to sue as it's not a crime and what have you. So I want you to read it. This is just a very brief summary of the case. Read the case, enjoy it, know the parties, know the various ramifications. But that's essentially what the action was about. And it was there a duty, so is there liability? In order to determine that case, Lord Aitken, if you forget every other law, Lord, negligence, don't forget this man. He did so he propounded what has been called the neighborhood principle, and they talked about reasonable foreseeability. Either there has been attempts even 100 decades before or 20, to formulate various principles of neighborhood, but this is regarded as a standard representation of what is the neighborhood principle. He formulated this and said, well, you look at the statement on your screen. The rule that you have to love your neighbor becomes a law, that you must not injure your neighbor. And the lawyer's question is, my neighbor receives a restricted reply. You must take reasonable care to avoid acts or omissions which you can reasonably foresee will injure your neighbor. Who then in law is my neighbor? The answer seems to be persons who are so closely and directly affected by my heart that I ought reasonably to have them in contemplation as being so affected when I am directing my mind to the acts or omissions that is being complained of. So this statement is loaded. It's loaded. A good student of this topic would actually be able to recite the statement. What is this talking about? Which rule are we talking about? Neighbor. You should love your neighbor. Lord Aitken took this principle. He tried to apply It's from biblical concepts. For those who have read the Bible, you would see there was a time someone came to Jesus and said, "Oh, what must I do to enter the kingdom of heaven?" And he said, "You must," and he talked about the fact that you must love your neighbor as yourself. And the man, he was a lawyer, interestingly, Nicodemus. The lawyer said, "Who is my neighbor?" And Jesus said, "Oh, those who are," he told him the parable. Jesus, instead of answering directly, he told the parable. He talked about the parable of this good Samaritan. In that parable, I will explain it. He said, "Oh, someone was on a journey, and as he was on the journey, he was attacked by robbers who took his things and beat him and left him for dead. And as he was there, at a point in time, a priest passed by. He saw him, he took another way, he didn't help him. A Levite passed by. These are supposed to be people of religion. He also took another way until a Samaritan was coming. A Samaritan was, and Samaritans and Jews were not supposed to be friends. They are not supposed to have anything to do with each other. This Samaritan saw this injured Jew, picked him up, took him to an inn, got medical, told them, treat him, get him treated, whatever is the cost, let me know, I'll pay for it. And he asked the lawyer, Jesus asked the lawyer that had come to him, who is the person's neighbor in this case scenario? So that is where Lord Aitken was coming from. So he now said, you should love that rule that you should love your neighbor as yourself. When you translate it into legal terminology, it means that don't injure your neighbor. Don't do anything that can affect your neighbor negatively. Don't always consider the interest of your neighbor in anything you are doing. And when he was asked, who is my neighbor? Lord Aitken moved from the biblical perspective and say, oh, from that case scenario, and say the neighbor is those people that are so closely affected by my acts or my omission. When I'm doing something or failing to do, who is so affected? They will be my neighbor. So every one of our discussions subsequently will be working on that connotation. In this statement, it talked about reasonable foreseeability. The thing that you can reasonably foresee. If it's not foreseeable, you may not say go a duty of care. So we are going to be looking at that foreseeability later. It talked about your neighbor, the people that can be affected. If I'm riding on the road, who is my neighbor? The neighbors will be those who are also road users, other car drivers, pedestrians, anybody that is using the road will be my neighbor. If I'm building this building, I'm constructing a building, I must be careful that I construct it well. Because if I don't do it well, who is my neighbor? People that will live in the building, the owner of the building, the people that are passing by the building, anybody that can be injured if the building, for instance, collapses, is my neighbor. Those who can come in, there is some measure of proximity that you can foresee. When I'm doing what I'm doing as a medical doctor, I want to treat a patient. I should foresee that if I do not do it well, that person can get injured. So those are the ways. So the neighborhood principle is very fundamental. And you would see from the way we have explained it, that the neighbor is not necessarily your geographical neighbor, but it's a spatial neighbor. It's not just about the person that is living next door, as we use it in ordinary language. The neighbor is someone that can be affected by my acts or omissions. It may not be it may be somebody you have never met before. If I'm driving on the road, I've not met the other driver before in my life, but that person is my neighbor. Because when I don't drive well, I can get the person injured. So those are the connotations of neighborhood. Now, this reasonable foreseeability, in that statement of Lord Aitken, he talked about acts that I can reasonably foresee would injure my neighbor. And so it's been said that reasonable foreseeability is a test of duty, is a test of breach, is also the test of damage. If it is not reasonably foreseeable, if the person you are not talking about guesswork. You can actually know by the way we live that, oh, what I'm doing can affect the next person. Who can it reasonably be foreseen that will affect? Like the example I gave earlier. So the train driver who has controlled the train in a negligent manner, and there has been loss of lives and injury of unimaginable proportion, and everybody is watching over the court. I'm watching through my television, you are watching through the internet, you are physically present, and you are looking at it. You are, is it going to be liable for all of us, the injury that we suffered? Oh, I lost money, I lost the relationship. We have to see that there must be a line. Otherwise, that person is going to be liable ad infinitum. If you say everyone that has been affected by my act of mission, I'll be liable. No, it must be within reasonable foresight. That is just one test. that has been developed in that case. Over the years, it was seen that that test, if you say reasonable foreseeability, then it could even go beyond expectations. So it is sufficient in cases of personal injury. If I'm driving a vehicle and flying a plane, I'm treating a patient, I'm handling the finances of a person or a company, I'm doing all these things, I'm making food and beverages and drinks, and I must know that anyone that is coming into contact with those activities can be affected by them. They can be injured by taking my drink if it's not well produced and it's killing people or making them injured. They can be injured if I do not treat them well as a medical doctor. You know, those ones are easy to foresee that they are my neighbors. But there are some people, so like the example I have given, or take another example, I leave my car on the road in a way that causes, accidents to others. Not only did it cause accident, or it causes traffic, and everyone, you are late for work because of the accident, you cannot meet your appointment. Maybe somebody has an exam that day, and because the road is blocked, they miss their exams and they do not get to class. Or someone is watching, sees has an emergency, they are taking someone to the hospital, and the road is blocked, and that person dies on the way. Can we make the person that left the car unattended on the road, that has caused traffic or that has caused an accident, can we make that person liable to all these people? Or someone that is watching the incident on television, someone that hears it on the news, or I forward it by WhatsApp to someone, I watch on YouTube. If we are not careful, if we look at reasonable foreseeability, it can take us to all dimensions and make you liable ad infinitum. That's what they call floodgates argument. It can bring so many people that you not conceive, can be because of prospective claimants. So it has been realized that we need other tests apart from reasonable foreseeability. So usually when it's personal injury, when it's property damage, you're talking about reasonable foreseeability. But when you talk about things like nervous shock, economic loss, pure economic loss, you begin to look beyond reasonable foreseeability and begin to talk about things like it beyond, yes, because inherent in reasonable foreseeability, we know it's what we call proximity. We talk about legal proximity, a kind of relationship beyond the fact that you are just someone that is going about. I want you to look at the statement of Lord Hoffman in Customs and Excise Commissioners against Barclays Bank and see this legal proximity issue, which I will also expatiate in subsequent slides and subsequent presentations. The proximity test, the cases that I've mentioned so far, Dologo and Stevenson, Hans and Martin, Caparo Industry and Dickman. I would enjoy you to read these cases. They all try to formulate this question of duty of care. Hans and Martin, Lord Wilberforce talked about a two-stage approach. Is there a sufficient relationship of proximity based on foreseeability? He tried to add proximity and foreseeability together. Say, look, you must be proximate to the person, and so that is why you can foresee the person. If a patient goes to a medical doctor, there's that legal proximity, that relationship, and that is how the doctor will see that this is a patient. So it can be a patient. If you are a patient in a hospital A, and you see Dr. A, it does not necessarily hold the patient in hospital B a duty of care. There must be some proximity. And there must also be evidence that nothing will negate duty of care. That sometimes the law will see that ordinarily there is duty of care, but they will hold that there is no duty of care due to some things like policy considerations, whether it is fair, whether it is just, whether it's reasonable. For instance, it's already established in law. When you are riding on the road, you hold a duty of care to other road users. It is an established duty of care situation. But assuming this driver there are a bunch of armed robbers, and they are driving away from the scene of a robbery so that they can escape arrest. And in the course of driving, they get injured. One of them, maybe the one that is driving, it actually happened in a decided case. And so the fellow robber was injured because of the negligent driving of his accomplice. And he sued his accomplice for negligence. And the law said, ordinarily, the general rule is that a driver, a road user, holds a duty of care to other road users. But in that case, the court said there is no duty of care because the law must take cognizance of other principles of law. Law cannot promote illegality. So if there are considerations that will make law to say there is no duty of care, you need to take note of those considerations. And that's why I said at the beginning of this lecture, you ask yourself that issues of policy, for instance, come into play. The law tries to look at the implications of what they want to decide against larger interests of society, against other areas of law. So these three cases, Donegal and Stevenson, Hans and Martin, Caparo Industries and Dickman, please take note of them in terms of formulation of the duty of care principle. So I said here that it is the issue of proximity, the neighborhood principle. They are effective in some cases, they are not effective in some cases. And that's why I say you take note of the kind of loss that person has suffered. If it's physical damage to property, if it's personal injury, foreseeability, reasonable foreseeability may help you. If it is pure economic loss, mental trauma, other cases where reasonable foreseeability is limited, you look at proximity. You look at proximity. I will be discussing this case of Hill and Chief Constable of West Yorkshire in subsequent presentation. But in that case, it's related to question of nervous shock, and they could not use reasonable foreseeability. So other tests were developed to assist claimants. Yeah, I also mentioned the issue of fair, just, and reasonable, which I explained that sometimes law will look at the facts before them and say, do we have any policy considerations where we should not have a duty of care? For instance, either to English law, it was a general rule, wrongly and worstly, that a barrister, a lawyer that is conducting a case in court, does not hold a duty of care to the client. When you are in the court, litigation, most of the policy issues relate to issues of floodgates agreement. We don't want to open the law to have thousands of litigation, that we cannot control the amount of cases, the number of litigants, and where it will end. So we look at it, at this law that we are creating, this principle, are we sure that it will not create a floodgate? And the barrister said, the law said, for policy reason, we cannot hold a duty of care to clients. If a lawyer were to go to court, and every time he goes to court, he loses a case, and you say the client can sue for breach, that means that every case that goes to court, the person that loses will sue his lawyer, that he did not handle the case well, that they hold them a duty of care. They say, oh, you didn't call 10 cases. If you have called 10 cases, I would have won the case. So every case will be litigated, because the loser in case A will sue and create case B. The loser in case B will sue and create a case, and you continue to have case upon case. So, and the court said, look, we cannot allow lawyers to be looking behind their back and looking at their client and ask to be sure that, okay, have I satisfied you? Lawyers owe a duty of care. They owe a duty to the court, to the cause of justice. They are ministers in the temple of justice. So they should not be controlled by the fear of litigation by their clients. This rule was in English law. Some jurisdictions don't accept it, and it has been restricted to the handling of cases in courts, not solicitors' aspect of the job, which you do in your chambers. Because those ones, the law felt, when you are in your chambers, you can actually take time to cross-check your rules and cross-check. But when you are standing before the law of the court, you are just there to present your case, and you have to do your best, and that best is good enough for the law. Of course, this law has been modified in English law to purely civil cases. So you look at it, is it constitutional to do that? How is it related? Can we situate this thing as pure criminal law, for instance, or do we make it to fall under contracts? So in Murphy and Brentwood DC, it says you don't want tort to eat up other rules of law. Don't expand tort so much that other rules of law, maybe contract, maybe commercial transactions, will be eaten up by just continuing to expand and expand. Of course, these are considerations that guide the decision whether there is duty of care or not. So I've explained this. Illegality, Aston and Turner, the law said there was no duty of care. When a robber, he was injured by other robber that they are trying to escape, imagine someone suing for that anyway. There's no honor amongst tips. Then there's barrister's immunity that I've talked about. So, but the House of Lords has removed this in Otto JS All and Simon by saying restrict it to the immunity against criminal against suing your lawyer as limited. Then the question of economic losses, which we are going to be talking as an independent aspect of the tort. So having said that, these are some of the situations that the law has held that there is a duty of care. If you are a manufacturer of a product your popular drinks in the country, for instance, that you drink anyhow, your food that you consume, those things that are manufactured, that you consume, or that you wear, or that you use, hair products, drugs, anything that is manufactured, and you know that somebody is going to use it anyway, then you as a manufacturer must make it well. You don't allow snails to be dropping out of your drinks, or allowing frogs or cockroaches to be found in your food product. Employers owe a duty of care to employees. When you're going to employ someone, you owe them a duty of care. Provide safe system of work, safe place of work, and these are major aspects of the law of negligence. You give your goods to a out, a bailor, a bailee holds a duty of care to the bailor. They give your clothes to your tailor to sew, your vehicle for a mechanic to repair, and they are telling you it's been stolen in my workshop. These are some of the areas that the law has established that you have a duty of care. A doctor holds a duty of care to the patient. A motorist holds a duty of care to other road users, clients, parents, and child. So it can go on and go on and go on. Now, I want you to take note of this statement. It is very important. And that is why the tort of negligence is also very important. Categories of negligence are not closed. Before, just now, I told you some established duty of care situations. Those ones have been recognized by law. So when you get to court and you have your cases, you don't have to be trying to prove to the court that a doctor owes a patient of duty of care. You don't have to be trying to prove that a driver on the road owes a duty of care to the other driver or to the pedestrian. You don't have to be proving that a manufacturer owes a duty of care to the, you don't have to start trying to establish that there's a duty of care. It has been recognized, and with our understanding of precedent, use those precedents. But the law also recognizes that after that general formulation of duty of care, you continue to have new situations and circumstances that can arise that you may have to prove that there's a duty of care. It continues to expand. Today, you talk about the cyber world, the internet world. So many things are new. Before, when I was a student, there was no phone, no mobile phone, there was no internet, so many things are new. And the law must respond to changing social needs and standards, changing relationships, new classes of people, new associations. So duty of care can continue to expand. Categories of negligence are not closed. What was negligent, what was not regarded as a cause of action yesterday may become a cause of action today. So Epitelier in that classic statement says, look, categories of negligence are not closed. And this can be like a question. Someone can give you this as a quotation and say, discuss. What are you going to write? You're going to talk about the meaning of duty of care and formulations, and then to help us to understand the fact that once that general formulation has been made, all you have to do is to show that, okay, can we say that there's a duty of care? Look at the neighborhood principle. Is there been breach of that duty? Has there been damage? And you apply to a new process of action. Okay? And continues to expand. As long as there are no policy reasons why we should say there's no duty, there's nothing that is preventing the court from saying that, look, floodgates argument can occur and what have you. So these are some of the ways to know that negligence, the sort of negligence is very dynamic. Now, who do you owe your duty of care to? You owe a duty of care to your neighbor. Remember Lord Aiken that said you should not forget about him in Donogo and Stevenson. The rule in law that you should love your neighbor becomes what the rule that you should love your neighbor becomes in law. You do not hurt your neighbor. Who is your neighbor? That judge in the Bible, when he asks the question, asks, who is my neighbor? Lord Donogo said, look, my neighbors are those who are closely and directly affected by my acts or my commissions. And I give the examples. If I'm a doctor, I'm treating a patient, I should know who my neighbors are. My neighbors are not people that I left at home for that purpose. But my neighbor is what? Those that I'm going to be treating, interacting with. When I'm asking for the patient's clerking, when I'm prescribing the drug, or the pharmacist. If you want to give the drug, there was a time a pharmacist gave me a wrong drug. It's that time. Luckily, she knew my number and had to call me. It wasn't my drug. There was another one that gave a blood hypertension drug to a child. Error, negligence. So the actions I'm undertaking, the activities I'm undertaking, or I'm failing to undertake, who can be affected by it? By my reasonable foresight, by the common man, the reasonable man, the ordinary man. If I'm riding, for instance, in the university, there are a lot of students about who are and they are walking, they are using their phone, they are gisting, they are talking, and I'm driving. The way that the ordinary person, the reasonable man, would expect me to drive in an environment like that is that I will drive at a reasonable speed. It is different from the way I would drive on the expressway when I'm going from one town to the other on an express road. How will I drive? It's different. I can increase my speed. So you owe a duty to this who can be affected by your acts or your wishes. So you owe a duty to a neighbor. There's no general, you don't have negligence in the air. It's not just that you owe it to everybody. It must be that the person that is suing in this particular case is the person that I owe a duty of care to. So there's no busybody. It cannot be a busybody. Is it that he owes you a duty of care? If the person does not owe you a duty of care, then there is no liability. In summary, for the purpose of this presentation, what we have done is that we have tried to introduce the thought of negligence and say that, look, when you hear the thought of negligence, it is different from the ordinary use of the word negligence. Why is it different? Because beyond that you are careless, it goes beyond carelessness or inadvertence. It is that you have breached a duty that the law has prescribed, called a duty of care. Not only that the law has prescribed a duty of care and that you have breached it, it must be shown that there has been what? There has been damage. If there is no damage, the thought of negligence has not been established. So negligence is not actionable per se. So there are some thoughts that are actionable per se, sort of trespass, for instance. But here, there must be some damage. It might be damage to your person. I was injured, my person, or my property. It might be economic damage. It can be, it can be emotional snapper shock, emotional injury, or whatever. You must establish to the law that a recognizable damage has occurred. In understanding the duty of care, we said you should take note of the case of Donovan and Stevenson. It's 81 years since that case was decided. Before that case, there was no general formulation of duty of care in negligence. Each of the cases before them were just different piecemeal approaches. You cannot say when I go to court, the court will say there's a duty of care or not. It's like a guesswork. Donovan and Stevenson distinguished, it made you able to come to court and sue for the infraction of a right. Outside contracts already existed to give you, when they have given valuable consideration, you can say there's a breach of contract. But here, the law said, look, you must have there are some cases where, irrespective of contract, there's a duty to take care. Duty to take care. Duty to be careful. Watch your actions. Watch your inactions. Who can it affect negatively under the law? So if Delugo and Stevenson is significant, Lord Aitken formulated the neighborhood principle that, look, you don't just hold duty of care, you don't hold it just in the here or to just anybody. You hold it to your neighbor. And it defined who is a neighbor. It defined it. And other cases, Hans and Martin and whatever, have carried it further and say, you're beyond your neighbor, you talk about proximity, you talk about other things that the law will consider. He said, Lord Aitken said, you must, that you owe a duty of care to you, those who can reasonably foresee will be injured by your act or your omission. So there are some keywords. Neighborhood, we talk about neighborhood. Reasonable foreseeability. So I can ask a question and say, reasonable foreseeability is the test of duty discourse. It means that it's not just that there is a duty. The duty is something that you must be reasonably foreseeable. You're not talking about possibilities alone, but probability, reasonable probabilities. Is it reasonably foreseeable? Can a reasonable man foresee? We are going to be looking at that reasonable man in subsequent tests. A reasonable man will see that this thing can cause an injury. We know that if I don't do this one well, this person can be injured. There must be reasonable foreseeability. It must be there must be a foresight, being able to see into the future, into the implications and the consequences of my action. And that, look, if it meets that test of reasonable foreseeability, then there's liability. But we say reasonable foreseeability is not enough, because there are some things that if you apply reasonable foreseeability to, it will create a floodgates of litigation. And so it is a bit deficient. And so I said that when you have a set of facts before you, if it is physical injury, if it is property damage, the reasonable foreseeability is likely to help you. But when you have injuries like pure economic loss, or you have injuries like failure to act, arising from failure to act, or you have something like nervous shock. You begin to go beyond reasonable feasibility. Talk about proximity, and I will be explaining those in subsequent presentations. What we mean by proximity and how it applies to things. And then you talk about floodgates and challenges. In the law of tort and in the thought of negligence, you'll be looking at that issue of floodgate argument a lot. Floodgate arguments are arguments that say, look, even if we are going to allow a duty, this case to go, it can cause problems for the law because it can create an indeterminate number of litigants for indeterminate courses of actions that, you just have people, everybody is able to sue. It's like everybody, all commerce affairs. And the law cannot allow all commerce affairs. It will whittle down, it would, erode justice. It says that the court will be overridden by litigation that it cannot even address. If I allow everyone that watched the train accident, everyone that watched from Australia to the US to the UK, everyone that's in Nigeria, in the village, it is an information age. Everything that is happening, the whole world can see it. And if because I watched it, somebody loses a pregnancy, if because they watched it, somebody loses their job, or if they became sick and they suffered mental health issues. If somebody who was standing there, even when it happened, working from their store, saw it happen, and they say, oh, because of that, I want to sue, or, everybody will be suing. Because if you say foreseeability, where do you end the foresight? So these are some of the issues that will arise in the course of our discussions. Because of the above challenges of reasonable foreseeability, the course have also created other tests like proximity, fair, just, and reasonable, and public policy. When they apply in each aspect of the law, we discuss their meaning. So what I've been saying is still that what test we apply is determined by the type of injury. If it's physical and property damage, look at reasonable foreseeability. If it's pure economic loss, nervous shock, negligence statements, we talk about proximity tests, we talk about public policy considerations, where you have liability of lawyers for illegal actions. These are some of the things that will come into play, and we are going to be looking at this in detail in the next presentations. So in looking at the decided case, always remember that there are other issues that may come into play. So sometimes you may look at the case and say, look, I feel like you should have held this person liable. But in fact, the court may say no for some of these reasons. And these are some of the resources that we have been able to look at. So in terms of making this presentation, I would expect that you also look at some of your recommended texts and try to dig deeper into some of the things that we have discussed. In subsequent presentations, some of the things key points that I've mentioned will be looked at: neighborhood, proximity, fair, just, and reasonable, policy. We are going to be looking at liability, special duty of care situations. This is just general application of duty of care. The application to certain areas will be discussed in subsequent presentations, like application for affirmative action, the application to negligent misstatement, application to nervous shock injury, and professional negligence of medical doctors, of lawyers, of architects, of whatever. These are some of the ways the law has tried to address the issue of duty of care. So what we have done in today's presentation is to look at the general foundation of duty of care. Subsequent presentations, we look at how duty of care is addressed in these specialized cases. Thank you very much for listening, and I hope to see you at the next presentation. Thank you.